to you this as I understand it. Now let me caution you right away that I am not prosecuting any part of this case. This case is being prosecuted in various federal areas, and the Steve Jackson segment is now the basis of a civil suit, a civil rights action, 42 United States Code 1983, against U.S. attorneys and the complainants. Let me give you the background on the case so you get a little bit of it. Again, this is as I understand it and as it was laid out on the Computer Underground Digest and in the proceedings of the ACM. Group of people knowing each other through bulletin boards. I don't know if they ever met face to face. Maybe they did, maybe they didn't. Got the idea that it would be interesting to look at the way the E911 system works. The E911, when you talk about messing with police records, is a key system to everything we do. It's how we stay in touch with the public we serve. You don't mess with that. That's vital to us. We wouldn't be doing this kind of job if we didn't believe in helping those people. And nobody is going to destroy that connection, that line of communication. And they didn't want to destroy it, apparently, but they wanted to find out how it worked and maybe suggest some improvements, and they thought that their readership would be interested in it, people that were listening to what they were doing. On the representation of a man here in Georgia, a student, that he could get the system, the publisher of a magazine, FRAC, again, according to what the ACM article is all about, indicated, well, that would be an interesting thing to do. Let's see what we can do with it. Somehow, this person down here got the information which he believed, well, I don't know what he believed, which was understood apparently to be some level of the documentation of E911, and put it on a board, and it transferred up here. Now, this person is a student, pre-law student at a college. He's using the college's data processing system to store this kind of information. Interesting, the college did not sue or even get sued by the victims of it, but that's the kind of liability we just talked about. It may be there, it may be coming. And after editing it, removing the proprietary protection information, that which they had was sent back over here, and it was on the boards, and everybody was talking about it and working on it and trying to improve it, ready for publication, which in fact happened. Now, where does Steve Jackson come into this? Well, from the information I have, one of the employees of a game manufacturer, Steve Jackson, here in Texas, was interested in this conversation. And when the case went down, warrants were served on each of these people, and the warrant here called for searching the employer's computer and seizing portions of it, because this individual, who had been identified for purposes of the warrant as being involved in this Legion of Doom, Operation Phoenix, liberating the 911, also had access to the bulletin board being used by a legitimate game manufacturer for commercial purposes. I'm sure some of your kids, maybe some of yourselves, I hope, play role-playing games. Well, this is a big industry. Dungeons and Dragons kind of began it, but it now is a popular activity. Sometimes it's on a computer. More often it's on a board or something of that sort. They talk about the games. It's a major, significant part of the games and recreation industry now. And so the proprietor had come up with a board named after a bulletin board for people to talk and communicate with each other. That system, that board, and other things were seized under the search warrant. Now, the issue in the civil suit, the civil rights action, is whether the warrant was badly drawn and whether the U.S. attorneys and the complainants should have known that. And I'm not going to comment on the outcome of that suit because it hasn't been resolved yet. It's still in the paper area. But the teaching point here is a rather clear one. You've got to make awfully clear to your employees, as apparently was done here. Again, I can't speculate on that. But the bulletin board is for company business and company activity. It is not for anything else, which raises certain questions as to the legitimacy of any kind of a bulletin board's use. There are laws that deal with this. Right now, the teaching point is this. There is a suit here. There is a suit going on down in Riverside County in California, and for all I know, other suits which are suing the complainant for a lack of probable cause in going to the police for reward. How do you avoid liability for that? That is something that we need to discuss. Let's take a look at the law. How are we going to protect you from liability on a civil rights suit, just as we're anxious to protect ourselves? Well, the law is not totally unrealistic. Police work by nature is going to be a risk. Sometimes innocent people are going to be arrested. Sometimes Stuff is going to be seized that is later suppressed, and that is a violation of civil rights, and some liability could lie. The United States Supreme Court has addressed this in numerous cases. And basically, if there is good faith on your end in coming to us with a complaint, and good faith by us in analyzing, and if we then, having agreed that there is a basis for a prosecution, go to the judge for the warrant and in full honesty disclose to the judge your concerns, our analysis, warts and all. In other words, any gaps in your logic we have to run by the judge. We can't hide the ball. We can't hide our real motive. And we get a search warrant, then to the extent that the action we are proceeding on stays within the confines of that warrant, we are immune. To the extent that we have distorted the truth or go beyond the warrant, then clearly we're outside the law and clearly we ought to pay. This is the United States of America, and we have a Constitution and a Bill of Rights, and no one moves with impunity against the rights of others. Everything we do is scrutinized by the law. Now, what is the standard, whether or not you were in good faith in coming to us for help? The standard is a perfectly reasonable standard. In fact, that's what it is. Under cases like Malley versus Briggs, and more recent cases here in California to the same point, provided a reasonable person with the knowledge you had could reasonably have formed the opinion that yes, you had probable cause to believe the offense was committed, that that person committed it, and that this intrusion, this search warrant, was necessary to prove that criminal activity, you are within an immunity. Now, this is a relatively new area of the law. It's an important area. It's one where a lot of reputations are going to be made and some refinements are going to be cranked in. I know that. I've been reading law for 30 years, and I know that nothing is ever set absolutely down. Good heavens, the 10 Commandments on 2 pieces of stone. Look at the number of law books we've got now. None of this stuff is laid out that simply or ever will be, which means when you take an action, you consider taking action, whether it's against an employee and you're looking down the muzzle of a possible wrongful discharge from employment suit, or a civil rights action if you're going criminal, because civil rights usually confines only law enforcement. It controls only the government, and that's not most of you. But if you're in cahoots, in conspiracy, then you could very well find yourself responding to those things. Be sure you've got your ducks in a row. Be sure you've checked out the law that you can do in good faith, and develop witnesses along the way. Proofread it. Have a member of your staff look at it. And that will give you that edge where you can proceed with confidence, at least as of November 11th, 1991, the day you're watching this tape. Is there anything more we need to know in terms of the strike back? Well, you should realize that there's a lot of distortion on this. And in this regard, you've probably heard of a group called the Electronic Frontier Foundation. This is their newsletter. It's called the Effector, in rather hard to read type, but that's what it is. I've had the pleasure of being on a couple of panels now and a couple of confrontations with Mr. Mitchell Kapor, who is, of course, the inventor of Lotus 123 and is now active. Last time I was on a panel, he had to leave before the afternoon because they wanted him to go down to Washington to testify. It would be wrong to consider this purely a protection of crackers of systems. As I've indicated, I don't think the term hackers is worth using anymore. It's too vague. Let me just quote what Mr. Kapor says in his newsletter here. There's a persistent view that the EFF exists solely as an institution to defend crackers of computer systems. This is an understandable perception, but it is false. The EFF does not condone the unauthorized entry into computer systems for any reason. There is no question that uninvited intrusions represent a major problem, and one which, and thousands of others struggle with on a daily basis. Their concern is that in the measures we in law enforcement take to curb this constant hammering, this constant prying, cracking, chiseling into your systems, the Constitution is observed and the innocent people, whether it's your company or a competitor's company, are not put out of business in the way in which we enforce the rules. Certainly no one I know in the High-Tech Crime Investigators Association has any argument with our staying within the Constitution. After all, we took an oath to uphold it. There will be continuing arguments, as you see in these civils.